Today, we're gonna go through some legal myths and we're gonna have you look at it from a lawyer perspective.
Got it, let's go.
If the police don't read you your rights, your case is automatically dismissed.
There are a few little crimes like DUI. It's got some real technical things around it, and you can get a DUI case dismissed if they don't read you your Miranda rights at the right time. But for the most part, the only thing that happens when they screw up and don't read your Miranda rights, or they can't use anything you say to incriminate yourself, right? So like, let's just say you robbed a bank and they catch you a mile down the street and they don't read you your Miranda rights, and you're sitting there and you say, yeah, I robbed that bank. That might not be able to come into evidence. Whereas if they read you your Miranda rights and you say that, the cop can come to court and he can say, hey, I was sitting there and Aaron said I robbed the bank. If he doesn't, your lawyer could then make a motion and say, hey, wait a second, no, you didn't read Miranda, you don't get to come into court and say that. But it doesn't mean you don't get charged. It doesn't mean they can't use surveillance footage of you at the bank to prove that you were the robber.
I told you that in confidence, Chris.
Yeah, I know, sorry.
So there's this big conception, or maybe misconception, that verbal agreements aren't legally binding, that you have to have it on paper.
There is something in the law called the statute of frauds, right? And it sets forth various different requirements that say what kind of contracts have to be in writing. There is no absolute requirement that a contract be in writing. First of all, understand that. Okay. You can make a verbal oral contract with somebody, but depending on the size of the agreement, how much money we're talking about, the scope, what area we're talking about, you could run afoul of the statute of frauds. The statute of frauds says for these type of contracts, we do have to have something in writing. However, there's several exceptions to the statute of frauds. But one of them is you actually start and perform the contract, right? Mm-hmm. So let's say you and I have an oral contract that you're gonna deliver furniture for me every day for the next month. You start doing it, and I start paying you. And we're starting to perform and this contract is happening, right? Something happens and it gets breached. And I can't say, no, we didn't have a contract because it wasn't in writing. Partial performance is an exception to the statute of frauds. So that's really what it is you can't have a verbal contract, but there are situations where the law requires you to have it in writing.
If you represent yourself, the court will go easy on you.
It depends on the judge. I've seen it go both ways. I've seen some judges that treat pro se litigants as the law says you should, which is the same as the lawyer, all right? When you go to a court, it's a voluntary choice to represent yourself, right? No one's making you do it. But if you do so at your own risk. And that's what the law says. Hey, you're expected to know the rules, you're expected to understand how things work, and you're not going to be given special privileges. Now, what happens in reality? I think most judges who are generally just good people and trying to be accommodating will bend over backwards for a pro se litigant, just to make sure that they understand the process, give them a lot of second chances that they may not give to a regular lawyer who's in front of them. So it just depends on the judge.
But it's like a huge gamble, right?
That's a tremendous gamble. It's a terrible idea. I've seen dozens of pro se litigants over the years, and I can maybe think of one time where they got a good result. The bottom line is, no matter what happens, at the end of the day, they always get a terrible result. It's been my experience.
Trust the experts.
That's right.
Next one up, we got, you can't be arrested for something you didn't do.
You can get arrested for anything. Or doing nothing. This is the question I get a lot. Can the cops arrest me for that? They can arrest you for anything. The question is, will it stick? Will you get a conviction to follow up, or will it get thrown out? Or was it so egregious that it's a false arrest and opens them up to civil liability? Police have a lot of power. They have the power to put the cuffs on you, take you to jail, make you do that mugshot, release it to the public, But the question of whether they can or can't do something is not decided right there on the street. It's decided in a courtroom years later, usually.
And if they do arrest you and it's found that they did not have a good reason, or they faked it or something, you can get compensated for that, right?
In some circumstances, not in every case. They get a lot of immunity too. There's a thing called qualified immunity. So they're really allowed to screw up. They just can't screw up really badly. You know what I mean? It's like there's limits to it, right? Yeah. But simple mistakes, it's really hard to hold them accountable.
All right, last one we got for you here today. A parent can disown their child legally.
When you say disown, I think of someone like putting somebody in their will, right? And so if I have I have a 6-year-old and a 5-year-old child, right? I can write my will and leave everything to you, and nothing would go to my children. Now, I have an obligation right now to feed them, to house them, to clothe them, to provide them with a reasonable education, all of those things, right? I can't abandon that. But as far as me in my will leaving things to my children, I'm under no obligation to do that. Now, my wife's a different story. She gets what's called an elective share my wife could still come in and claim 1/3 of my estate.
All right, Chris, well, that's what I had for you today. I'll get some more together and we'll do this again. It was fun.
Love it.